Today I want to speak clearly and candidly about a report published by the ACLU of Michigan, Human Rights Watch, and MOESH. And that report is urging the repeal of Michigan's parental consent statute. On its face, of course, it presents powerful anecdotes and emotional claims about judicial bypass and alleged harms to young people. But in my opinion, beneath that veneer lies a deeply flawed piece of advocacy disguised as scholarship. And that distinction matters when public policy and constitutional liberty is at stake. First, the empirical foundation of this report, in my view, is profoundly weak. It draws on its core findings from a very small and non-representative sample of interviews. They interviewed lawyers and providers and advocates who are institutionally aligned against parental involvement. Let me say that again. They interviewed people, the people that they interviewed were all aligned against parental involvement requirements. There is little to no direct testimony from the broader population. There is no testimony from people that are affected. For example, no testimony of parents, judges who handle bypass cases, minors who successfully involved a supportive parent, no interviews of professionals outside the reproductive health advocacy sphere. And so this lack of representative data means the report does not measure prevalence. It only measures selected impressions. And so, second, the structural advocacy bias permeates the methodology all throughout, in my view. All sponsoring organizations have publicly committed to opposing parental consent laws. Their chosen interviewees share that alignment. Good qualitative research demands triangulation. That is in academia something we call triangulation, is engaging diverse viewpoints to test hypotheses and to challenge assumptions. This report offers none of that. By contrast, advances predetermined conclusions, in my view. Third, the report leans heavily on anecdotes, not data. Powerful as individual stories can be, they do not substitute for systematic empirical observation. There are no frequency estimates, no control groups, no baseline comparisons, just isolated experiences with no way to tell if they reflect widespread harm or isolated hardship. Fourth, the report lacks comparative legal analysis, in my view. It never meaningfully assesses how Michigan law compares with jurisdictions, for example, that use alternative models. Nor does it explore whether harms supposedly unique to Michigan are actually common to many regulatory frameworks. Without that comparative lens, claims about harm are unanchored from context and make broad policy prescriptions irresponsible. Finally, and most fundamentally, the report blurs normative judgments with empirical claims. It treats value-laden assertions that parental involvement inherently violates rights or autonomy, for example, as if they were empirical facts. But constitutional and legal reasoning demands clarity between what is and what someone thinks it ought to be. Conflating the two undermines credibility and corrodes public policy and corrodes sound public policy debate. And let me summarize here and close. Because of these methodological defects, small and skewed samples, advocacy bias, anecdote over evidence, absence of comparative analysis, and normative conflation, this leftist report cannot sustain, in my view, the sweeping conclusion that it purports to make, especially the call to repeal Michigan's deeply rooted parental consent law. Public policy that affects families and fundamental liberties deserve far better than advocacy masquerading as evidence. Until next time, this is Professor Wagner for Faith and for Freedom and for such a time as this.